border control and global justice. My name is Katia Faria. I am a postdoctoral researcher here at the Center for Ethics, Politics and Society at the University of Minho, and I'll be chairing the session today. So just to remind you, as you know already, each speaker will have 20 minutes for presentation and then 10 minutes for Q&A. I will ask each of you to be very strict with the time so that we can have the 10 minutes for discussion. We don't have many people attending, but since the topic is very common to all of you, I hope that we can have a fruitful discussion. Okay, so we will start with Bradley Hillier-Smith from the University of Reading at the UK. And the title of the talk is Direct and Structural Injustice Against Refugees. So Bradley, thank you. And whenever you want.
Cool, thank you. Let me just try and share my screen here. Hold on. All right, can everyone see that?
Yes.
Okay, so thank you very much for the opportunity to present. So this paper is a work in progress and it's called Direct and Structural Injustice Against Refugees. And it's aimed as a constructive critique of Serena Parek's recent normative analysis of certain harms that refugees face as a result of Western state practices. So to provide the theoretical background, the dominant ethical framework for understanding obligations towards refugees is what I call the duty of rescue approach, according to which states in the global north, or Western states as Parek prefers to refer to them, these states are innocent bystanders overlooking the harms and humanitarian crisis of refugee displacement unfold. And these states have duties to rescue refugees from these harms, either through aid or settlement or other means, at least if they're able to do so at little cost to themselves. And this approach is dominant in the literature. Serena Parek's recent analysis, however, has taken aim at this dominant approach, and she suggests that, well, Western states are not mere innocent bystanders or potential rescuers, and this is an inaccurate framing of Western states' role vis-a-vis refugees. Instead, Western states engage in numerous practices that result in significant harms to refugees once they are displaced. So Parek draws attention to two particular harms. The first is the containment and encampment of refugees, where Western states seek to contain refugees away from their territories in regions in the global south near refugee states of origin, where they are left to reside in camps for prolonged periods of time, and Western states politically and financially support housing refugees in these camps as their preferred response to refugees. So that's the containment and encampment of refugees. The second harm that Parek draws attention to is refugees' inability to access refuge, which she understands as the minimal conditions of human dignity, which consist of adequate physical security and subsistence. And the idea here is that Western states adopt various practices of deterrence, prevention, and containment of refugees, which effectively leave refugees with three options once they're displaced. They can either spend prolonged periods of time in these squalid and dangerous camps, or they can face destitution in urban areas in regions in the global south, or they can risk their lives on increasingly dangerous journeys to reach adequate refuge in the global north. So as a result of Western state practices, refugees are unable to access adequate refuge, these minimal conditions of human dignity. So for Parek, both these harms, the containment and encampment of refugees and refugees' inability to access refuge, are injustices against refugees for which Western states are responsible. So far from being mere innocent bystanders or potential rescuers, as per the dominant duty of rescue approach, instead Western states are responsible for an injustice against refugees. Moreover, Parek suggests that these injustices are structural injustices, which in her own words are not necessarily the result of deliberate wrongdoing or explicitly unjust policies, but are the unintended outcome of the actions of different agents, states in this case, each working for their own morally acceptable ends. And this is the point where I part company from Parek. So I agree with pretty much everything she argues. I agree that the containment and encampment of refugees and their inability to access refuge are significant harms against refugees, and that they are injustices against refugees for which Western states are responsible, but I disagree that they are structural injustices. Instead, I argue that they are and ought to be understood as direct injustices against refugees. So to clarify the terminology, a structural injustice is defined, and this definition comes from Iris Marion Young's influential account on which Serena Parekh's arguments rely. So structural injustice on this view is distinct from harms and wrongs that result from direct individual interaction, is distinct from harms and wrongs that are the direct result of actions and policies of states or other institutions, and is instead an unjust outcome which is the unintended consequence of structural processes, which are constituted by a multitude of uncoordinated agents and policies, each adhering to morally acceptable ends. By contrast, a direct injustice, as I define it, is straightforwardly an unjust outcome which is directly caused by and attributable to specific and identifiable policies enacted by relatively unconstrained actors. So my argument that the harms that refugees face should be considered direct injustices consists of two components. The first is a theoretical conceptual claim, which is essentially that containment, encampment, and the inability to access refuge, these harms do not fit the necessary conceptual criteria to instantiate structural injustices, insofar as they're not the unintended byproduct of structural processes distinct from individual wrongdoing or policies. They are instead direct injustices, insofar as they are the direct unjust result of specific and intentional policies enacted by unconstrained state actors. So I point to a few examples in the paper. So one, the famous or infamous 2016 EU-Turkey deal. As part of that deal, refugees are encamped on the Greek islands and are contained in regions in the global south in Turkey, Jordan, and Lebanon, where they face the prospect of living in camps for prolonged periods of time or destitution in urban areas. Also, the EU Memorandum of Understanding with Libya in 2017, which sees the interception of refugees and their detention on the Libyan coast, and the containment of refugees in regions in North Africa, preventing them from accessing refuge in the European Union. Also, Australian Operation Sovereign Borders, which similarly intercepts refugees, processes them in offshore detention centres, and contains refugees in regions in Eastern Asia. And also US deterrence policies such as the fast-track deportation and separation of families act as a deterrence for refugees and prevent them from accessing adequate refuge in the United States, and instead contains refugees in Central and Southern America. And I suggest that a direct result of these specific policies and practices is the containment of refugees in regions of the global south, the prospect of them spending prolonged periods of time in camps without any prospect of accessing adequate refuge, and their inability to access refuge in the global north. And I suggest that these must be direct injustices insofar as these harmful outcomes directly result from specific policies devised and implemented by state actors. So I deal with a couple of objections to my analysis here. This objection is a bit of a non-starter, so we'll move on to the second objection. So here's an objection to my view. Well, this unjust outcome, as in refugees being contained, encamped, and unable to access refuge, doesn't derive from one single policy or one particular piece of legislation or one state actor individually. So no one state has caused this overall injustice. Instead, it's the cumulative result of numerous policies enacted by uncoordinated state actors, each initiating their own policies. But the cumulative result of all these states doing so is this unjust outcome. So therefore, because this is so, it must be a structural injustice. My reply to this objection is I provide some historical detail on the well-known historical injustice of Jim Crowism, the segregation of African Americans in the southern states of the US in the latter half of the 19th century. And as I demonstrate with some examples in the paper that I don't have the time to rehearse here, Jim Crowism emerged as a result of different individual federal states enacting their own different policies, laws, and codes regulating racial relations within those states. And even different cities and municipalities within those states had their own different laws, policies, and codes. So for example, Tennessee is often cited as introducing the first Jim Crow law, which segregated train carriages. Then other states followed suit, segregating different public spaces and marriage. And some states had very pervasive and restrictive codes. and some states had very distinctive codes themselves. So Louisiana segregated prostitution, and Alabama segregated to have black Bibles in courtrooms and so forth. So different states adopted their own distinctive laws and policies. However, the outcome of these states acting in this way is well known: the comprehensive segregation of Black Americans from white spaces in the south of the US. And then when we look at this example, it's clear to me at least that Jim Crow segregation is not simply an unfortunate unintended outcome distinct from individual wrongdoing or unjust laws, such that it would instantiate a structural injustice. Instead, we correctly regard the Jim Crow segregation as a direct injustice against Black Americans, insofar as it's the direct result of specific policies and practices enacted by relatively unconstrained actors. And so we might infer from this case that even if an unjust outcome derives from uncoordinated multiple actors, that's not sufficient to establish a structural injustice. And therefore, even if the containment, encampment, and inability to access refuge derive from uncoordinated multiple actors, that's not sufficient to establish a structural injustice. Instead, it remains a direct injustice insofar as it results from specific policies enacted by relatively unconstrained actors. In the paper, I then make the broader claim that the parallels are sufficient to suggest that the separation exclusion of refugees from Western spaces, resulting from different states enacting their own containment laws and policies, is a form of Jim Crowism in the modern era. And as such, it's a direct injustice against refugees. Now, the second component of my argument is a more normative claim. And essentially the idea I'm trying to get across here is it matters greatly whether we understand these harms against refugees as structural or direct injustices. It makes a huge difference. Because if we understand these harms as a structural injustice, then this absolves state actors and any policies of wrongdoing, and it results in a weak and non-binding framework of responsibilities to address the injustice, which I'll explain more in a moment. But for now, recall that Serena Perec criticizes the dominant duty of rescue approach on the grounds that it casts Western states as innocent bystanders and potential rescuers with weak and discretionary responsibilities to help refugees if they can do so at little cost. However, on the structural injustice model of responsibility that she provides, on this model, no state is acting wrongfully. No policy or policies are directly unjust, and no agents or policies directly cause the injustice or any direct harms to refugees, and none should be blamed for their acts or omissions. Instead, the injustice results from structural processes beyond any agent's control. And I include here a quote from Perec, where she writes, "We Western states are responsible not because we have done something wrong or something that we should feel guilty about. We shouldn't blame each other or call each other guilty for causing the injustice. Instead, all connected in constituting and reconstituting the structural processes that cause the injustice have a remedial responsibility to address it, since they can do so at little cost." So that's the structural model of responsibility. And Perec suggests that in many ways, Western states are like the person watching a child drown in a shallow pond. We're able to do a lot without sacrificing anything of moral worth. And so there are a number of objections to this model of responsibility, namely that it seems to absolve Western state actors of any wrongdoing for significant harms to refugees. For example, it risks absolving EU state actors for their arrangement with Libya, which sees the interception and detention of refugees in horrendous conditions where they face extensive human rights violations of torture and enslavement. It risks absolving those state actors of wrongdoing and risks casting those policies as not directly unjust. And furthermore, it seems that the responsibilities don't seem any different in kind than the duty of rescue approach that Serena Perec is aiming to criticize, because it's similarly casting Western states as innocent, not doing anything wrong or unjust, but with responsibilities to help if they can do so at little cost. So it doesn't see obvious why, having established that Western states are connected to this injustice, her responsibilities are any different to the standard duty of rescue approach. And third, the responsibilities don't seem any more stronger or binding than the duties on a duty of rescue approach. I mean, after all, no state is acting wrongfully or is directly causing any harm. So it's hard to see why these responsibilities to fix the structural injustice are particularly compelling or binding, given that no state has done anything wrong as directly causing the injustice. It doesn't seem that they're any more binding than standard duties to alleviate a harm to which one is not in some way connected. So it doesn't appear to provide any advancement on the duty of rescue approach. And in fact, an even more alarming problem arises insofar as the structural model of responsibility is forward-looking, insofar as it's not backward-looking in seeking to assign blame or guilt or wrongdoing for any of the harms caused or for anyone's actions. Instead, it's forward-looking. It's simply focusing on the injustice in front of us and working out ways we can address it together. But a problematic implication of this forward-looking model is that if an agent fails to fill their responsibility to address the injustice to which they're connected, then they should not be blamed for their omission, and they are not acting wrongfully. And therefore, on this model, the responsibilities are even more weaker and more discretionary than the standard obligations on the duty of rescue approach, because on the duty of rescue approach, states have fundamental duties to help refugees if they can do so at little cost, and are acting wrongfully if they allow refugees to suffer and fail to help them. So it seems that Serena Parekh's model of responsibility, her structural model of responsibility, doesn't provide any advancement on the duty of rescue approach to which it's ostensibly an alternative. It similarly casts Western states as innocent, doing nothing wrong, as potential rescuers with discretionary responsibilities to help if they can do so at little cost. And more alarmingly, allows states to fail to fulfill these responsibilities and fail to help refugees without acting wrongfully. By contrast, on a direct injustice model that I'm proposing, not only does this more accurately characterize the relation between Western state practices and the harms that refugees endure, but on this model, states are indeed acting wrongfully and are adopting policies and practices that are directly unjust and cause direct harms to refugees. And as a result, states that adopt these policies and practices have strict and compulsory negative duties of justice to refrain from unjustly harming refugees. And such negative duties, as we know, are widely considered to be stronger than positive duties to help if one can do so at little cost, and are much stronger than remedial responsibilities to address a structural injustice to which one has non-wrongfully contributed. And so therefore, in conclusion, I've suggested that there are strong theoretical and normative reasons to understand the harms that refugees face as a result of Western state practices as a direct and not a structural injustice. The containment, encampment, and denial of refuge constitute direct injustices against the world's refugees. And therefore, it follows that Western states are not mere innocent bystanders. They're certainly not mere innocent bystanders, and they're not merely non-wrongfully involved in structural processes that result in an unintended harmful outcome, but instead committing a direct injustice against the world's displaced. And therefore, these states bear compulsory negative duties to refrain from causing such unjust harms to innocent refugees. And I'll leave it there. Thank you.
Thank you very much, Bradley. So we now have 10 minutes for questions. Anyone? Okay, Yuan?
I think you're muted.
Yes, you're right. I'm still muted. Sorry. Yeah, thank you so much for your presentation. I'm very much sympathetic to what you're arguing, but I'm wondering whether we have to choose between the structural injustice model or the direct injustice model, or maybe there are some elements of both in the current injustices suffered by the refugees. Because one thing I'm wondering about the direct injustice model you are proposing is that if we understand the injustice inflicted on refugees in the current situation, then there should be an obligation of institutional reform, because there is one potential explanation why refugees cannot have adequate access to refuge is that there is a problem unfair, like a problem of coordination. Nobody want to take, or some people do not take their fair share of accommodating refugees, which resulted in others need to do much more. And this problem cannot be solved by just like directly one state take more action and take more refugees. And that problem can only be solved by really institutional reform at the global level. So I'm wondering whether we can think about this in the dual track. There is both systematic structural injustice or systematic structural inadequacy of the institution of the current global institutional regime. On the other hand, some states do directly engage in injustice against the refugees. Yeah, thank you.
I think that's, thank you for that. That's a really good question. So I think when you were talking about sort of some of the failures of states to act and take in sufficient numbers of refugees, and that there's insufficient institutional coordination of states to fulfill these obligations, such that we have a situation where refugees are unable to access refuge. I guess I wonder whether that's helpfully described as a structural injustice, whereas you might just think, well, that's just a failure of states to fulfill their positive obligations on the sort of duty of rescue approach kind of thing. So it seems that I think kind of Parek's model of a structural injustice is kind of trying to incorporate both ideas that one, states are engaging in these practices, and also states are not fulfilling their obligations to help, and this results in this injustice. But I kind of think that, well, this misunderstands the situation. I think it's clearer to kind of focus on, there's certain state practices that are directly unjust and contributing to these harms, and also states are failing to fulfill their positive obligations. So I'm kind of raising doubts about the benefits of using this sort of structural injustice approach here, because it seems to paper over some distinctions between moral obligations, if that makes sense.
Okay, so I think Leonardo also has a question.
Again, muted.
Muted.
So thank you, Bradley, for your presentation, which was brilliant, actually. And I don't want to discuss the theoretical points you presented to us, but as a Brazilian, maybe I have some question, because Brazilian government has opened its borders to Haiti people, to people from Haiti and Venezuelans. And one of the European fears is that, so what if we open the borders and simply, not detain refugees anymore, and maybe there is some sort of overburdening of costs, because we will be overwhelmed by the costs of hosting all refugees that want to wash up in Europe and so on. But the thing is, on the one hand, when Brazil made this decision of opening the borders, there was a sense of trying to prevent smugglers from controlling the situation, the passage from Haiti and Venezuela to Brazil. But at the same time, we just find out that the number of smugglers actually increased. So this is a real challenge, because on the one hand, we have this, this attempt to a remedial justice of allowing refugees to enter, etc. But at the same time, we face this risk of smugglers and drug dealers trying to control the territory. So maybe this could give you some insights at the theoretical level. I don't know.
Okay, thank you. I mean, if I understand it correctly, there might be a sort of moral hazard of what I'm saying here, because suppose the states refrain from adopting these practices that I've described as direct injustices, that could result in perhaps unforeseen greater harms and might even exacerbate the situation. I mean, obviously that's an empirical question, but I don't think it seems, at least at first sight, that plausible, because we know that smuggling networks, etc., and some of the dangers that refugees face do obtain as a result of certain practices and infrastructure that states adopt. And I know this more so with reference to the European Union case, and that, you know, increased border infrastructure and these deterrence measures don't stop smuggling. In fact, they might increase the need for it. But so, yeah, I don't have an answer to that. Like, it's quite a broad empirical question, but I think there's reason to doubt that refraining from detaining and encamping and containing refugees and denying their access to refuge would result in overall harm. I think that's a reasonably plausible assumption to have.
Okay. I believe that Jack also has a question. Am I right?
Yeah, I was just applauding, no question.
Okay.
But thank you.
Okay. So we still have time. Any other questions? So maybe I can make a small question. So I was thinking, if the model you're presenting applies both to refugees and asylum seekers, or if you think that's any kind of relevant difference. So I need to know this before I ask my question.
Well, no, I'm not making a distinction there. I think it applies to both. Yeah.
Okay, so then thank you. So I was thinking about a particular case I'm quite familiar, which is a specific case of refugees, of LGBTQ asylum seekers or refugees. And I failed to, I'm not sure how this particular case would fit in your model, because I failed to see in what way the Western practices might be directly causing this kind of injustice.
Mm-hmm.
So I wanted to hear you on that.
Oh, sorry, what was the case exactly?
The case of LGBTQ asylum seekers, which by persecution based on sexual orientation, they seek asylum in other countries. No, so
okay. So I guess
for that specific reason.
The injustice against them would be the fact that they are prevented from accessing asylum because states adopt a lot of containment measures that prevent refugees from being able to access Western territories and refuge. And also adopting various practices, which means that they face very few options once they're displaced from their state of origin. So they're essentially locked out of adequate refuge and face a situation where they can either spend prolonged periods of time in refugee camps or face destitution in urban areas, or risk their lives on very dangerous journeys to try and access refuge. So the injustice against that group, assuming it does apply, is that they are less able or unable to access asylum. If that makes sense.
Okay, yes. Maybe I was thinking of a more broad understanding of the injustice at hand, but I now understand that you're specifically talking about the injustice once you're displaced.
Right, sorry,
okay,
yeah, I should have made that clear. So I'm not talking about injustices in the causes of displacement.
Okay.
So I'm not suggesting that, although some philosophers have made this case, I'm not making this case that Western states have caused refugees to be displaced. I'm saying once they are displaced, and are seeking safety, Western states adopt certain practices that result in harms to them.
Good. Thank you. Is there any other question? No? Okay. So thank you, Bradley, again.
Thank you so much for your questions.
So now we have Leonardo Barros da Silva Menezes from the University of Minho, and the talk's called Could Refugees Live Anywhere They Want? So Leonardo, whenever you want. Thank you.
Thank you. Can I share my screen with you?
I think so.
Okay.
Good.
Okay. So first of all, thank you, Katia, and thank you, Antonio, for organizing this event and for the opportunity of presenting my paper. And in this talk, I raise a few critical questions about a just distribution of refugees between states and argue that such a scheme must be balanced against the legitimate interests of refugees in their destination country and the duty of states to ensure that they are settled in places where they are likely to flourish. So I proceed as follows. I begin with considering the features of a normatively adequate definition of who is a refugee, arguing that the humanitarian designations of states' adequate duties to refugees is unconvincing to some extent. And I move to a short examination of the main features of the current distribution of refugees between states. Then I explore the question of how to determine each state's share of refugees and raise a few critical questions about the current models of refugee relocation between states. And I conclude by considering the acknowledgement of refugee agency in the global governance of refuge and asylum. So first, I want to ask you who should be considered a refugee, or actually who should be entitled to such a special status. And this question may be seen irrelevant, as states have already agreed on the legal definition of persecution under the 1951 Refugee Convention. Still, when normative theorists discuss who is a refugee, they tend not to use this legal definition, but rather a more inclusive approach. So rather than emphasizing the reason why, persecution, for example, an individual's human rights were violated in determining refugeehood, these scholars have seen the moral core of refugeehood simply in the need for protection. But the problem is that each one of these definitions has its own moral as well as political costs and implications for normative thinkers. For example, supports of the convention-based definition like Matthew Price usually stresses that the moral distinctiveness of persecuted refugees by claiming that states' persecution can lead to a sense of alienation and distrust so profound that they lose political tie with their community in such a way that we should not expect them to return home even after war or the end of dictatorship. And a first objection which might be raised against it is actually how restrictive is this definition in our today's world and for the phenomenon of displacement. And by contrast, if displacement is just a matter of individual motivation, like Joseph Caron's definition, then no refugee would be morally different from immigrants, except for the urgency of their needs. This claim is not uncontroversial either, as the use of such a broader definition may give rise to more than 20 million people seeking asylum. However, what's important for us is to think of what these definitions have in common. And essentially, all of them gives substance to a certain humanitarianism as the source of states' duties to displaced people. This is not problematic in itself, but we should ask ourselves how justice is conceptually envisaged here. And it seems, from this point of view, that firstly, these are recipient-oriented points of view, which are centered exclusively on goods, rights, and distribution. And secondly, that this approach disregards the political issue of who determines the institution of refugeehood. In other words, my question is about the place that refugees should occupy, not as victims, but as agents of their own lives. So when it comes to the relocation of displaced people between states, the view that the only morally relevant dimension of a refugee's plight is her lack of physical protection is, or at least seems to me, dubious. But I will go back to this claim later. Before I move to discuss some of the ethical challenges of constructing a more equitable system for refugee relocation, let me be clear about the current distribution we have. A striking feature of world's refugee population is that it's overwhelmingly congregated in poor states, as we can see on this table, and according to the UNHCR's Global Trending Report from 2019, developing countries now host more than 80% of all the world's refugees. And given the fact that the responsibility for refugees has been distributed on the basis of geographical proximity between poor states, I assume that the current distribution not only exacerbates inequalities between southern and northern states, but it's also morally problematic. So the first question I come up with is actually, what is a fair share? And here we face problems because there are a number of potential candidates for determining fair shares. One standard is for the responsibilities or quotas of states to be determined by strict numerical equality. And in this approach, every state would take an equal number of the world's total refugee population. For example, the United States, Kenya, and Luxembourg would be each one responsible for 50,000 refugees. But the obvious objection to the numerical equality approach is that it doesn't take into account the relative costs to states of resettling refugees. So the challenges, for example, for the US, of taking 50,000 refugees are vastly different than for a tiny country like Luxembourg or Kenya. So let's suppose we can reach agreement on a normatively defensible refugee definition and that we can construct an account of fair shares for each state. So what do we do next? Peter Schuck has proposed a finance-based market system in which states could trade their quotas with other states, enabling the most efficient allocation of refugees according to state preferences, as well as an opening up of availability of asylum. But two issues, I claim, emerge from this model. Firstly, from a moral standpoint, it risks of commodifying refugees in a system where states could buy or sell quotas of one another. And secondly, from a political point of view, it's easy to imagine how the status quo, that is, the existing global symmetries between states, would still be reinforced by this distributive scheme. So an alternative model is offered by Will Jones and Alexander Teitelbaum, who propose a system in which the legitimate preferences of states and of refugees, expressed as rank order sets, could be algorithmically matched. But putting aside this modification, an essential component of each of these proposals is the same, that refugees should be sent to where they're receiving asylum best promotes justice between states. So to shuffle refugees between states in this way means in practice ignoring the preferences of refugees as to where they want asylum. And this trade-off is certainly an overriding of refugee choice, which is justified in pursuit of a good end, namely distributive justice for states, which is closely connected to justice in the provision of asylum for refugees. But refugees would be treated largely as people with little interest in where they end up beyond the guarantee of basic security. Now, it's quite reasonable to object my last claim with two reasons. One reason why treating this way refugees is necessary is because if refugees were allowed to make their own choices, a fair distribution would be undermined. So one might say refugees have no moral claim to gain asylum where they want. They have a right only to state protection in a safe country. In other words, refugees are entitled only to a place in which their basic rights are respected and they are protected from refoulement or return. If Finland or Norway needs to fulfill its quota, then refugees from Somalia would be required to go there, regardless of any preference they might express for Kenya, Australia, or the US. And a second reason has to do more specifically with John and Teitelbaum's algorithmic system. So according to their model, refugees are allowed to rank the countries they want to live in and hence to express their preferences, although states give the last word on who they will host. Then one might ask, why wouldn't that be legitimate given refugees' individual rankings? And I want to offer two distinct responses for these objections. And by doing so, I hope to give you compelling reasons on why refugees' right to choose and right to voice should be granted and is related to their role as agents and not only as humanitarian victims. So addressing already the first question, a common assumption is that what morally separates refugees from immigrants is simply that refugees lack the protection of a state. As long as substitute state protection is found, refugees have no strong moral claim to reside in the country of their choice than any other immigrant. As quickly as normative defenders of refugee distribution schemes make this claim, they tend to step back from it in the following cases. Firstly, as is daily evident in the life risking journeys from home to Stockholm, from Calais to London, refugees often have strong preferences for and against particular countries. They typically want to be in countries where their ethnic kin or compatriots are already settled, where there are opportunities to practice their religion and cultural tradition without hostility, and where local labor markets are receptive to their skills and abilities. While their interests in integration may not be as urgent as their need for physical security, it's likely to be pivotal in refugees developing into dignified members of their new society. And secondly, this case of recognition is even more compelling if we conceptualize asylum not simply as a humanitarian act, but also as a mode of compensation for the harms resulting from flight. So, but what exactly were the harms associated with being made a refugee? To be a refugee is not simply, in this case, an individual who has lost the protection of her basic rights. It's to be someone deprived of her social world. It's to be someone who has been displaced from the communities and cultural context that have shaped her identities and plan. And this broader sense of what refugees have lost is relevant to how we conceptualize asylum as a reparation. So if asylum is a form of compensation for the losses incurred because of state malevolence, negligence, or ineffectiveness, then ideally it should offer the refugee not only physical security and basic rights, but also a place where she can rebuild a meaningful social world. And we cannot ignore the fact that for any particular refugee, this act of rebuilding is going to be easier in some countries than others. Just what makes a suitable asylum country depends on the particular refugee in question in this case. So concerning the second objection, that of Jones and Teitelbaum's matching system, I don't oppose to the outcomes of a system in which refugees might rank their preferences. Still, it remains the question whether refugees are simply treated as a humanitarian problem. If these persons are allowed, on the one hand, to choose their country of preferences, they, on the other hand, are not given suitable justification on why they are not eventually picked up by the country they wanted mostly. So given this lack of justificatory power, in Heiner Faust's terms, refugee voice would be limited on the applicability of its rights to participation in the justification process, at the risk of becoming a mere passive recipient of state's decision. Then what's crucial, I think, to substantiate refugee voice under a distributive scheme is the idea that that limitation posed by such a matching system can be overcome if the institutions of refugeehood are designed to prevent the moral arbitrariness of states' hosting of refugees. In other words, such humanitarian understanding can be overcome by understanding how refugees' positive rights can contribute to states' problem solving and how states' problem solving can contribute to refugees' positive rights. At the core of this mutual re-elaboration is the idea, firstly, of deliberation as reason giving in a context relative to the purposes that concern refugees as well as states. And secondly, the idea of struggling against arbitrary rules of some institutions over some people without legitimate reason, where struggles are conducted against unjustified forms of injustice. So in conclusion, the problem is, of course, that taking into account considerations of integration risks undermining distributive justice between states because it makes it more likely that some states will be favored over others. That's why it's tempting to operate with the diminished view of what refugees need. So is there a way out of this difficulty? The obvious answer is to compensate those states that end up taking in more than their fair share of refugees because they prove to be a popular destination. But this compensation could involve an alleviation of some of the state's other responsibilities, towards refugees. For example, duties to help finance UNHCR, for example. But besides, there is something pretty intuitive about this conclusion. It appears to bring us to the place where we started, actually, with substantial inequalities in refugee numbers between states, about now provided with some compensation. But the justification for these new inequalities would be substantially different. The current inequality in the distribution of refugees emerged largely because of differences among states in their ability to prevent refugees from arriving on their territory, differences associated with geographical location, and the efficiency of control measures. And the new inequalities, however, would be a consequence of states recognizing both that distributive justice between states is an important goal and that refugees have a powerful and legitimate interest in where they receive asylum. So thank you very much.
Thank you, Leonardo. So we now have 10 minutes for questions. Any questions? I know that Antonio had a question, right? Mute.
I was just clapping.
But don't you have a question?
Perhaps, but I'll leave it to the end if no one has. Okay.
Okay, Bradley.
Hi, thanks so much for that. That was really interesting. There was one bit that I just wanted to ask you to clarify a little bit more. So I think you said, you're arguing that it's false that state protection is a sufficient fulfillment of states' responsibilities to refugees. And in fact, much more is required. We need to take more interests into account, maybe their preferences, and also compensate for some of the harms of a loss of the state and being displaced. And that was what I wanted to ask about. So when you said compensation for these harms, and I think you're right, there are huge harms that come with displacement that states ought to respond towards. But when you say compensation, that kind of implies perhaps that the states are responsible for these harms and thus have to compensate them for it. So which might be right. I mean, if what I argued earlier on, if some of that's true, then maybe you're right. But I just wondered, is that what you're going for? Or are you just sort of saying, no, we just ought to respond to these additional needs?
Should I ask Bradley's question and then the other ones?
We have Bradley's question, then we have 3 more questions.
Okay, thank you very much, Bradley. This is really good question, because actually when I think about compensation, I was wondering about, actually I was considering the relation that social scientists recently have been developing between the difference of internal and external factors for influencing how states fail actually, and then they generate say forced displacement. And in this case, I was thinking about the responsibility of states who are located outside, but at the same time, there is some sort of, I'm thinking out loud, but maybe I was trying to think about also if the global system or the institution of refugeehood is not able to respond to a certain challenge, then it might be cause a certain problem of legitimacy as well, not for one state, but for the whole community. So I think I cannot give you a precise enough, a good response for it, but maybe I was trying to look to both of these dimensions. On the one hand, the idea of social scientists and explanatory effects, etc., and then this other dimension.
Cool. If I may just come back quickly, I think that's right. I think that's a really good idea, and maybe you're aware of it, maybe you're not, but David Owen and Joseph Cairns have argued similarly that there's a legitimacy of the state system, and when the state system fails, as it does with the case of refugees, then states owe refugees protection and other things to compensate for the failure of the state system in which they're part. So yeah, I can send you those if they're helpful.
Thank you very much. Can I just replicate once more?
Of course, it's your talk.
It's because maybe my basic concern was because I don't agree usually with, for example, David Miller or Thomas Nagel when they see that justice is only a matter of domestic level of domestic issue, because the point is, how can we identify other sources for triggering norms that are more requiring than humanitarianism? So in this case, I was trying to think about, at the global level, how can we conceptualize this sorts of injustice? But thank you very much.
Oh, my pleasure.
Okay, so now we have 3 more questions. Let's start with you. Sorry, with Yuan, por favor.
Thank you so much for your presentation. I really enjoy it. My question is, if I understand your position correctly, you want to give refugees the final say about where they want to live. Is that right? So it should be for the refugee to decide where would be their final destiny. Yeah.
As a matter of to provoke you, I would say that as you have asked Bradley about the possibilities of, say, replacing the institution of refugeehood or sustaining from the institutional point of view what we have actually, I would say that this is much more a final word for refugees. So the idea is, I was trying to show that even in a perfect world of 5-5-5 equality, there will be no equality because states' integrative capacities differ from one another. So the point is that there are also other sorts of injustice which are located in the domain of refugees. And then maybe the point is that we usually consider that refugees would always go to Europe or North America, but maybe empirically I have no data to prove my point, but feels like this is not the case. I think, for example, that refugees from South America would stay in South America, and refugees in Asia, to say Asia as a whole, would probably stay in some country located in Asia. So I think the idea that refugees couldn't have voice or a political voice because all of them would go to either United States or Europe, maybe it's for me a bit problematic in this sense. So it's much more a challenge. So how could this be?
I'm less concerned about whether refugees will all opt for going to the United States or going to Europe if they got the final say about where to go. I'm more concerned about the structure of your, like the normative grounding why you want to give refugees the final say. Like, it sounds like your justification for giving refugees the final say is we should respect the refugees as moral agents rather than simply treat them as humanitarian subject. But on the other hand, it seems like the other states or the other communities, we should also treat them as agents, like moral agents. And it seems like the balance model do a better job of treating everyone as an agent. So like people who want to go to US, but maybe the US are more, like if everyone want to go to the US, just like by stipulation, but the US are more willing to accept, like say, for example, English speakers rather than refugees may potentially struggle more of learning English, then it seems the preference of the US people or the sovereign state should also be respected to some extent. So I'm wondering why if we are thinking about respecting moral agency, the final outcome should be we should always respect the agency, the choice of the refugees. Yeah. Thank you.
Of course, go ahead.
Thank you very much, Yuan. Actually, you're absolutely right in this point also. And my point is that I wouldn't have time to develop this idea, but what I was thinking about normatively, or at least institutionally, was how could we determine some sorts of, say, transnational injustice, in the sense that if refugees want to go to the United States, suppose all refugees want to go to the United States, so should American citizens simply accept that they would be equals? But I think that this is not exactly the point, but it's much more about how could American citizens offer justifications for rejecting refugees' entrance, or say for accepting them, but mostly because in this case there should be compelling reasons for saying no to refugees. And it doesn't mean that all refugees have direct access to a given country or state, but it's much more about how justification takes place in this case. So I would say that I should develop a lot more about this idea of refugees as agents, because you are absolutely right about how could refugees would respond to it. But I would say that this is much more about a boundary problem, you know, and then we can justify why not, or why they should have access.
Okay, since we already have 2 more questions, so maybe we will take the 2 questions and then you will answer them together. Please keep it short. We only have 3 minutes. Okay, so we have we start by Jack Magic, and then we have João Ribeiro.
Yeah, Joy, you can go ahead. My question was really about responsibility, sort of like Bradley's. So it's mostly just recapitulating that. So don't worry about it. But thank you.
Yes. Okay. Thank you. Thank you very much. Very, very interesting. The idea of ranking the preferences, and then treat refugees not as agents, and not only as humanitarian victims. And you mentioned forced right to justification. And if I understood correctly, the idea is that to a certain extent, you have to have a justification to ignore or to decide in a different sense than what the ranking preference showed. But I was wondering whether the idea of the right to justification can be so broad, or if it is conceived to be used internally to a society and a culture. Because I think that what you're saying, taken to the last consequences, imply a certain cosmopolitanism in a way. So the idea that there is a global right to justification, there is, I mean, if the refugee can rank preference, and the states have to justify to explain why not following the preferences, this sounds more like a cosmopolitan duty towards the states. And if this is so, why stop there? I mean, if there's a right to justification as to where to live, what about other claims people may have? I at least in first thought, it really sounds too broad in a way, you know. Thank you.
Leonardo, you have 1 minute to answer.
Okay, João, thank you very much for your question. Actually, yes, I 50-50 agree and disagree with you, because Heiner Forst actually he uses his idea of justificatory power and so on at the domestic level, but at the same time I think he's a little bit ambiguous, because when he develops his concept of transnational justice, then I'm not sure if his frame goes until say a cosmopolitan feature, but it's much more about justifications from transnational justice. And even though he doesn't say much more about refugees, he was much more concerned, for example, with the multinationals and how they could explore workers anywhere in the world. And then we could use this idea of justificatory power to struggle against transnational injustice. So in this case, I think even Forst is kind of ambiguous because I don't know, maybe this is just an interpretation, my interpretation of Forst, but I think I would advance this idea. So I'm not sure if I was enough to give you a good and compelling response, but this is it.
Okay, thank you very much, Leonardo. We now have our final presentation from Yuan from the Virginia Commonwealth University. The title of the talk is Border Control, the Right and the Wrong. So thank you, Yuan. Go ahead.
Let me share my screen. Thanks so much for coming to the presentation, and thanks to the organizers to put this together. So the title of my presentation is Border Control, the Right and the Wrong. And the border control is a big topic. So in order to get to the particular question I want to tackle, I want to start by laying out the scope and the assumption of my argument. So in this talk, I'm only concerned with migrants whose fundamental rights are not at risk when they seek immigration. In this way, the scope of my argument will be exactly in contrast with the two previous presenters. They are focused on refugee problem, but I'm focused on, people say, like optional immigration. So I will further assume that a legitimate state has a quantified right to decide whether to admit a would-be migrant, namely when the migrant's fundamental human rights are not at stake. So this is a central premise of the current legal framework of the international migration system. And of course, I know this is a very controversial thesis. Many people argue that no state should have this unilateral right to control migration at all. So for those who are not on board with this premise, you may treat my argument as an internal criticism of the existing understanding of the framework. I hope that by giving a more adequate understanding of the current framework, we will be better positioned to evaluate whether it's normatively acceptable. So when a state operates within its right to control borders, there remains a further question of whether its specific immigration law is morally justified. So when a state makes immigration laws, it ought to base its decisions on the overall balance of pertinent reasons, properly considering the legitimate interest of both its citizens and its non-citizens. So on one end of the spectrum, a state's immigration law is justified, or like I can say just, when it strikes a balance, the proper balance of all the pertinent reasons. The way to justice is a very, very narrow path. It's very hard to really hit the balance of all the reasons. On the other end of the spectrum, a state's immigration law is illegitimate, like falling out of the state's unilateral right to control when it is egregiously unjust. For example, if the state just refuses refugees whose fundamental human rights are at danger, even though it obviously has the capacity to accommodate that, as Bradley argued earlier. So the space between justified and illegitimate immigration law is the space where the state has the right to do wrong. And this is the space I want to explore more. So just to give a more concrete example about unjust but legitimate immigration law. So I will refer to unjust immigration law that a state has a right to administer unjust but legitimate. So suppose that the US is considering a policy regarding certain kind of migrant workers. Just to simplify the issue, assume that there are only two considerations that are relevant and they pull in the opposite directions. So the would-be migrants versus the US citizens' legitimate interest. Both are legitimate interests in working in the US. So assume that the would-be migrants' interest outweigh the US citizens' interest, so that the really just policy is to allow migrant workers to enter and work. However, the US adopts the opposite policy, namely not allowing migrant workers to come based on the wrong but reasonable belief that US citizens' interest outweigh would-be migrants' interest. So under those assumptions, the law that prohibits such migrant workers from coming, call this law the prohibition of migrant workers, falling into the conceptual space I want to explore, which is they are unjust but legitimate. So what should one do regarding unjust but legitimate immigration laws? There are two existing positions. So Hidalgo argues that the injustice of a particular immigration law is sufficient to justify non-compliance. And on the other hand, Young that non-compliance is justified only if the law in question is illegitimate. So despite their stark disagreement, Hidalgo and Young share the assumption that citizens and would-be migrants' the obligation to comply with the state's immigration law stand or fall together. And this is the assumption I want to challenge. I want to challenge their shared belief. I argue that normatively speaking, immigration law affects citizens and non-citizens differently. So give a more concrete example. Consider that Brenda, a would-be migrant from India, whose basic rights are not at stake. She seeks to enter the US as a migrant worker for significantly better life opportunities. The US denied her the permission to enter or work based on the prohibition of migrant workers. So Hidalgo's position entails that Brenda is morally permitted to enter because the law is unjust. And the US employers are morally permitted to hire her, both disregarding the unjust law. However, Young's position would entail that Brenda is not permitted to enter, nor are the employers permitted to hire her because the law, despite its injustice, is legitimate. Here's what I want to say. I want to argue that Brenda may be permitted to enter and seek employment. However, the US employers are not permitted to hire her. So I know it's probably a little bit of a weird position to take. So here's my central thesis. It has two prongs. So first, citizens of the state are typically morally obligated to comply with unjust but legitimate immigration law. However, would-be migrants may often be permitted to violate such laws. This is because that legitimate immigration law has authority for citizens but not for non-citizens. And I also have two broader aims. The first is to reconcile a state's moral prerogative to make, apply, and enforce its legitimate migration law with would-be migrants' moral permission of non-compliance under certain conditions when the state's legitimate law falls short of justice. Also, I want to propose an attractive reconceptualization of immigration amnesty. Namely, immigration amnesty is a mechanism where a state corrects its injustice of its previous immigration policy, rather than an encouragement of lawlessness. So first, I'm going to talk about the relation between immigration law and the citizens of the state itself. And then I will talk about the relation between immigration law and non-citizens, and then conclude the talk by take a look at the immigration amnesty. So I want to justify the state's right to control immigration based on the problem of unilateralism. So we all know that immigration has significant impacts on a society, no matter whether it's about economic growth, labor market, public health, or welfare programs. So society has to make univocal decisions regarding immigration control, whether to adopt an open border, if not, who can come, who can't, under what conditions, that the citizenry together need to come down with one decision on those questions. While univocal decisions are necessary, the citizens commonly disagree about what policies the society should adopt, often on reasonable grounds. So amid reasonable disagreement, no private citizen has the moral standing to unilaterally settle the disagreements and impose their own favored decision on those who disagree. So it is commonly accepted that a liberal democratic state has legitimate authority over its citizenry to make adjudications when citizens have persisting disagreement about issues of justice. So consistent with this common belief, I argue that such a state has the authority to regulate immigration at the national level because it solves the problem of unilateralism when it comes to border issues. So first, the state has de facto authority, which means it is capable of implementing its univocal decisions in its territory and thus effectively liberates its citizens from one another's private imposition. And procedurally, the state allows citizens to shape its decisions at least at a fundamental level, and thus respect everyone's moral agency and their interpretation of justice. And substantively, when the state's immigration law are reasonable, which means like a competent person based on reasonable conception of justice can arrive at this kind of immigration law, that I will say that the immigration law is reasonable. So when the state's immigration law are reasonable, even though it falls short of really strike the balance of reasons so that it falls short of being completely just, those laws legitimately settle citizens' reasonable disagreements about border control, and thus should be considered as authoritative resolutions for the citizenry when it comes to their collective action regarding the border control. So the above conception of legitimate authority of the state heavily draws on the Kantian account of authority, especially established by like Arthur Ripstein and Anna Steels. I want to take this account one step further. So recall that no private person has the right to settle reasonable disagreements about immigration regulation. The state's legitimate authority to do so is an exclusive right because no one else has it, and the state has the unique moral standing to settle issues of immigration. So when the state vests power to decide immigration issues exclusively with particular officials, those officials acquire the exclusive right to settle how the citizenry ought to proceed as a collective regarding immigration regulation. So which means those officials are exclusively answerable to reasons that determine the justifiability of a state's immigration law in the process of making, applying, and enforcing the law. So civil servants and ordinary citizens are neither permitted nor required to respond to those reasons according to their personal judgment, their private judgment, when they act as required by the law. So consider the prohibition of migrant workers again. According to my account, the law settles how citizens ought to act collectively regarding whether to admit and employ migrant workers. After the state has unjustly but legitimately denied Brenda the permission to enter and work, potential employers in the US should not act upon their private judgment about how to balance would-be migrants and their fellow citizens' legitimate interest in finding work in the US. The law excludes the reasons that the lawmakers have duly considered. So the law's authority becomes the sole consideration for potential employers in deciding whether to hire Brenda, and thus they just ought to comply with the law. So the exclusionary account, the exclusionary power of the law is most prominently defended by Joseph Raz. However, Raz tried to argue for the exclusionary power of the law based on the alleged superior epistemic competence of officials. In contrast with his approach, I justify the exclusionary power of the law based on the state's unique moral standing to settle reasonable disagreements about justice. So now let's move to consider the relationship between immigration law and non-citizens. So as argued earlier, the state has legitimate authority over its citizens to regulate immigration, which implies that its decisions have the exclusionary power for the citizens. However, the state lacks such authority over non-citizens. A state and non-citizens relate to each other as they stand in a state of nature, basically. Each is entitled to act upon their good faith judgments about the balance of reasons. The state's right to decide its immigration law is merely a claim right against non-citizens. So the concept of claim right comes from Caulfield's topology. Basically, a claim right imposes a correlative obligation on others, but this obligation is merely a potential obligation and can be outweighed by contravening reasons. So I want to use like a private case to illustrate the normative structure of a claim rights. So suppose that Mary invents a medicine and has the property right to the medicine. The medicine can cure infections that may cause recurring migraines or paralysis for different people. Now, Tori gets recurring migraines caused by the infection, and Emma's leg will be permanently paralyzed if she does not receive timely treatment. So Emma's legitimate interest to get the treatment is much weightier than Tori's, as you can see. Assume that they are all in a state of nature, and Mary denies both Tori and Emma the cure because they cannot pay for it, which on both counts is impermissible, but within her property rights. So plausibly, Mary's property right can outweigh Tori's legitimate interest to avoid the migraine. That means even though Mary should not deny Tori the medicine, Tori should nonetheless respect Mary's decision. In contrast, Emma's legitimate interest to avoid paralysis may outweigh Mary's property right. Thus, it may be permissible for Emma to steal Mary's medicine if this will not cause any other harm for Mary. So I want to draw an analogy between this case and immigration. So like Mary's property right to the medicine, the state's right to decide its immigration law is merely a claim right rather than an authoritative settlement respecting non-citizens. So depending on the weight of a non-citizen's legitimate interest to enter, a non-citizen may or may not be permissibly violate a state's legitimate but unjust immigration law. So would-be migrants whose interest to enter is fairly minor, for example, tourists, their situation may be more like Tories, even though a state unjustly denies them entrance. They may still nonetheless morally obligated to respect the state's decision. However, there could be would-be migrants, even though their fundamental human rights are not at issue, at stake, but they actually have very extremely weighty reason to enter. Then their situation would be like Emma's, even if the state's immigration law is legitimate. Their legitimate interest to enter may nonetheless outweigh the state's legitimate interest to control the state's right to control migration. So consider Brenda from India again, who was denied admission to the US based on the prohibition of migrant workers. Assume that by entering the US, Brenda can significantly improve her life, like moving from poverty to middle class, at little or no cost to the US citizens. Brenda's legitimate interest to enter may well outweigh the US's right to control its border. Thus, Brenda would be morally permitted to enter, disregarding the US law. So the ultimate difference between Brenda's normative situation and her US employer's situation is that Brenda is permitted to act upon reasons that the US lawmakers have duly considered, while the US employers are not. That's why there's a wedge between how the citizens basically normally should always bind by the legitimate immigration law of their own states, while would-be migrants may often be permitted to enter or disregard the legitimate law. And now let me just tie everything together by quickly look at the immigration amnesty issue. Immigration amnesty is the process of granting legal immigration status to persons who are in the state illegally. The standard objection against immigration migration is that those who entered illegally disrespect the law's authority and should pay the price for it. Amnesty would only reward lawlessness. However, as I argued earlier, immigration law lack authority over non-citizens even when they are legitimate. And many undocumented migrants were morally permitted not to comply with unjust but legitimate immigration law, and thus they should not pay any extra price. Immigration amnesty is better conceived as a procedure where the state corrects previous injustice, where it denies admission to those who should be given legal immigration status in the first place. Thank you so much. I will stop there.
Thank you. Thank you very much. So we have 10 minutes for questions now. Please raise your hands. Okay, so let's start with João Ribeiro.
Okay, thank you. It was very, very, very interesting. Thank you very much for your presentation. I was wondering whether any theory of sovereignty applies there, because I think there might be a tension. You were making the presentation, and I was imagining Hans Kelsen country saying, "This is the way we rule our country. So we have this block legal system. So this is a neo-Kantian, as you mentioned, approach to sovereignty." Where Carl Schmitt wanted to come in, saying, no, sorry, this is a decisionist approach. So it's not about, let's say, a closed legal system, but it's based on my decision. I'm not under that, because I had a hard time understanding the idea of the state of nature. I think I'll take issue with that. I mean, is Brinda in a state of nature with the US? I'm not. I mean, it's interesting. So I was wondering, do you consider that the theory of sovereignty is of any relevance there? And is there a tension in both perspectives? I mean, from Brinda and from the employer, are they looking at it from very different angles and probably impossible to reconcile? I hope my question made sense. Thank you.
Yeah, thank you so much. That is a question really at the heart of my position, and I really think a lot about that. So I do think like my argument really based on a very peculiar understanding of sovereignty. And according to my conception of sovereignty, internal sovereignty and external sovereignty do not operate in the same way. So internal sovereignty, the relation between the state and its own citizens, involve a very robust kind of authority, where as I trying to say that the state's legitimate decision typically is really conclusive for its own citizens because it's supposed to settle their disagreement about justice. However, I do acknowledge states also have external sovereignty, which operate just as a pro tanto claim right, which means the other people who are not their subject has some reason to respect the decision of the state. However, it's not as much as like the state's decision should replace their own judgment. So this drives the wedge between the obligation the citizen have towards the immigration law and the much weaker obligation non-citizen have towards the immigration law. So I hope this kind of differential treatment of the internal and external sovereignty can stand, because my argument really rely on that kind of wedge. Yeah.
Okay, anyone else? We still have a few minutes. Anyone?
All convinced?
You are very convincing.
That would be very surprising, because almost any philosophical position will generate like tons of objections.
It's true. Okay. Yeah, Bradley, go ahead.
Maybe this is just ignorant, but is it the case that you argued that, okay, so Brenda might have a particularly strong interest in entering, therefore she could enter, but because citizens have an obligation to obey the law, they ought not to employ her? Is that, so what, I mean, it sounds really naive, what's she supposed to do?
Yeah, that's a really good question. So here, I'm actually trying to exploit the moral weakness of potential employers, because I do believe most employers employ undocumented migrants out of prudential reasons rather than moral reasons. Even though morally speaking, I argue they should not employ undocumented migrants, but I think they may still have sufficient prudential reasons to do that, because the enforcement of immigration law is not like always watertight, and the punishment is typically fairly minor. So even if as a matter of morality, they should not, but they will still nonetheless do it. So I hope all undocumented migrants will have the employment in the place they enter. Yeah. I still feel a little bit weird about that position, but that's what I have now.
Okay, well, maybe there's some sort of like, method of using different degrees where you could say, well, depending on the particular strength of the potential migrant's interest in entrance, I don't know, but there seems to be, yeah, there'll be a difference between employing tourists and employing Brenda, and I think so. Maybe there's a spectrum you could work with there.
Yeah, I cannot really make use of this suggestion, even though it's such a reasonable suggestion, because of the exclusionary power of legitimate directives for the citizens. So no matter what's the reason, the non-citizens are denied admission to the state, those reasons have already been duly considered by the lawmakers, and that's why the employers should no longer rethinking those reasons again. So, but on the other hand, I want to say, like, in terms of moral culpability, if somebody hire a migrant who have really, really strong reason to enter, then I want to say they may be less culpable, because when we think about culpability, the strength of the migrants' interest may be considered, yeah, but not for like permissibility.
Okay.
Sorry. We still have a couple of minutes. Is there any other questions? Okay, Bradley.
Okay, this one, maybe this is beyond the scope of the paper, but I was trying to get my head around the idea of there being an unjust but legitimate law. Maybe this is just because I'm unfamiliar with the literature, but it seemed to be, well, it's legitimate insofar as it's democratically agreed upon amongst citizens and lawmakers, but it's unjust insofar as, like, from a moral point of view, it doesn't appropriately take into consideration the balance of competing interests. So it seems to me then that has applications for like refugee policy as well. And I know you said this is not in your scope, but suppose the state democratically decided we're not going to help refugees at all. In fact, we're going to institute horrible policies to get rid of them and all the rest of it. And that would be a legitimate law, but an unjust one. And you would think, it follows from your argument, that citizens would have an obligation to follow that law and not help refugees enter or things like that. Is that true? I'm just kind of trying to think of the implications of this legitimate but unjust law idea.
Yeah, so that's a really good question, because I rely on the existence of a gap between legitimate law and the just law on the other hand. However, to have legitimacy, like for a law to have legitimacy, to have a democratic credentials is just like one necessary condition rather than a sufficient condition. So you need to both have democratic credential, but also be reasonable. But reasonable laws may not just, like as I said, like strike the balance of reasons. Like just to use other examples, for example, the health insurance in the United States. We don't have like a single payer system. However, suppose like the single payer national health insurance is really just, but the US system maybe is already crossed the threshold of legitimacy, even though it's fall short of full justice. So come back to your refugee example. So if the democratic populace decided we're not going to allow refugees to come in, the law would not be reasonable, even though it passed the democratic pedigree requirement. Yeah.
Okay, that makes sense. Thank you.
Okay, so I think this is the final one. Okay, so thank you very much, Yun Yuan. Thank you, Leonardo. Thank you, Bradley. So I'll see you in, I think, half an hour for the plenary talk. So thank you and have fun.
Yeah,
Thank you very much.
Yeah, bye-bye.